You ready? Okay, good morning. We'll call the meeting to order. Welcome to the Police Policy Committee for May 22nd, 2025. I'm going to read our administrative announcement for the Police Policy Committee. This is a public meeting subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by the Police Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. A perceived conflict of interest means that a relationship to any given case has the potential to impact one's decision-making process, even if there is no personal or monetary belief to be gained or benefit to be gained. This must be stated for the record. Members may participate in discussions, and a vote may still be cast. In contrast, an actual conflict of interest means that one does stand to gain, either personally or monetarily, from a decision that is made. This must also be stated for the record. Members must not participate in discussions, and a vote cannot be cast. Further,
are you done with that part?
No, that part.
Okay, Chair, Captain Copeland for the record. So at this time, with all of the cases that we're hearing, I'd just like to pause and identify if anybody has actual perceived conflict of interest that they want to get on the record, and then we'll go through our cases.
Sheriff Brandenburg, for the record, you probably have heard that the Oregon State Sheriff's Association moved to remove Sheriff Vander Camp from our membership. So I wanted to, that may be seen as a perceived conflict of interest, but those are different circumstances or a different set of rules that DPST has, and it may be some of the same material that we are reviewing here. Certainly not all the material that we will be reviewing here, but I can remain objective and look at all the evidence that is in here being presented before the Police Policy Committee. So I just want to put that on the record that I don't believe that that is a conflict of interest for me, but may be perceived.
Duly noted. Thank you, Sheriff.
Sheriff Michelle Duncan, saying there may be a perceived conflict. However, I don't have anything to personally or financially gain. Based on this vote, I too participated in the Oregon State Sheriff's Association vote to remove Sheriff Vander Camp from Oregon State Sheriff's Association. Again, I can make a vote objectively based on the material presented today.
Thank you. Appreciate that. Chair?
Chair Downing, for the record, anyone online need to weigh in? Hearing no one, I'll continue. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to other persons in the room or makes it impossible to continue the meeting. Now we'll call for introductions.
When I call on you, please state your name and who you represent for the record. We'll begin with you, Chair Nowning.
Scotty Nowning, Non-Management Law Enforcement at the Salem Police Department.
Vice Chair Conning.
Casey Cotting, Superintendent, Oregon State Police.
Member Barrett.
Tanisha Barrett, Beaverton Police, Non-Management Law Enforcement.
Member Brandenburg.
Sheriff Brandenburg, Oregon State Sheriff's Association representing.
Member Daniel.
Mark Daniel, Chief of Police, City of Mount Angel, representing the Oregon Association of Chiefs of Police.
And then we have Member Gajovic online.
Good morning, Chris Jovic, Deputy Chief of Police, Portland Police Bureau.
Member Dresser.
Kevin Dresser, Tiger Police, representing non-management law enforcement.
Member Duncan.
Michelle Duncan, Lynn County Sheriff, representing the Oregon State Sheriff's Association.
Member Livingston.
Teresa Livingston, Major, representing OSP Command Staff.
Member Lofgren.
Patty Lofgren, I'm a public member.
And we have Member Olson online.
Doug Olson, FBI.
Member Townsend.
Megan Townsend, Hillsborough Police, Non-Management Law Enforcement from Oregon Peace Officers Association.
And Member Wood.
Robert Wood, representing the public.
And now for staff introductions, both in person, online, and guest introductions. If you're here, I'll begin. Executive Assistant Walt Lopez, DPSST.
Eric Riddell, Criminal Justice Support Specialist, DPSST.
Melissa Langbacho, DPSST.
Phil Castle, Agency Director, DPSST.
Jennifer Howell, Rules Coordinator, DPSST.
Cindy Park, DPSST.
Catherine Calpine, DPSST.
Marie Atwood, DPSST.
Sam Fanny, DPSST.
Kathy Fink, DPSST.
Jennifer Lavario, DPSST. Audrey Anderson, DPSST.
Celine Stevens, KGW News.
Richard Gordon, KGW News.
Thank you, and I believe we have 2 staff members online. Jared Rayburn.
Jared Rayburn, DPSST.
And Bree Murphy.
Bree Murphy, DPSST.
Thank you, back to you, Chair.
Thank you. Has everyone had a chance to review the minutes from our previous meeting, which was held on February 20th, 2025? Looking for requested modifications, or we will confirm by consensus to approve the minutes. Getting thumbs up? Any objections? Hearing none, we will adopt the minutes from the February 20th meeting. We'll now work on administrative closures. Are you going to do that, or is Melissa going to?
Melissa.
Okay, thank you. So I'll turn it over to Melissa, the case manager for our administrative closures. Thank you.
Thank you, Mr. Chair. Melissa Langbacher for the record. The department completed 8 reviews and is making a recommendation to administratively close those cases. They are on a consent agenda for the committee's review. The department is seeking a vote to approve or return the cases. Mr. Chair.
Thank you. Scott Downing for the record. Are there any questions or is there discussion regarding any of the administrative closure cases? Anything that needs to be removed from the consent agenda? No questions? Hearing no questions. Online, no one has any questions? No concerns? Hearing none, I'll call for a motion to approve the consent agenda as presented.
Baird, all in.
Daniel for the record, I'll second.
All right, we are voting on a motion to approve the administrative closures. Chair Downing.
Aye.
Vice Chair Cotting.
Aye.
Committee Member Barrett.
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Daniel.
Aye.
Committee Member Jovic.
Aye.
Committee Member Dresser.
Aye.
Committee Member Duncan.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lofgren.
Aye.
Committee Member Townsend.
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Thank you. We'll now move to the professional standards case reviews, and I believe the first will be Sheriff Vander Camp, which will be presented by Captain Calhoun.
And that's number 8 for those on our agenda. And Catherine Calpine, for the record, Deputy Director, will also be presenting along with Cindy Park, our compliance coordinator. This case is for Sheriff Vander Camp. On December 6, 2023, a complaint was received by the department regarding, at that time, Sergeant Vander Camp of the Deschutes County Sheriff's Office. The complaint was determined to be jurisdictional and forwarded to the Sheriff of the DCSO for review. On March 2nd, 2024, the department received additional information from the complainant, which was also forwarded to DCSO for review. In response to the information provided, the DCSO opened an internal affairs investigation. The sheriff notified Vander Camp via memo dated August 15, 2024, that an independent investigator has been appointed to review the information provided in the complaint. The initial complaint was received prior to Vander Camp's election as the Deschutes County Sheriff on November 5th, 2024. On November 14th, 2024, a memo was sent to DCSO, then Sheriff Nelson, from the Deschutes County Legal Counsel requesting that DCSO refrain from issuing any disciplinary action / sanction above a level of reprimand letter without first securing review and approval from Risk and Legal. A memo written by DCSO's Undersheriff on December 5th, 2024 stated that DCSO closed the IA administratively. The memo indicated that the independent investigator was completed. However, the office did not complete the disciplinary process because Vander Camp, who was now the sheriff-elect, went out on personal leave prior to a Loudermill hearing occurring. So on December 30th, 2024, the department requested documentation from the completed DCSO.
It's Jessica Adams, hide me pin.
A professional standards review was opened to determine if the reported behavior violated board-established employment training or certification standards for public safety professionals per Oregon Administrative Rule 259-008-0300-3F. On April 7th, 2025, the department was notified that the Deschutes County District Attorney's Office had completed an investigation related to false or misleading statements Vander Camp made while testifying in criminal cases regarding his education. Upon completion of the investigation, the Deschutes County District Attorney determined that Vander Camp had made false statements while testifying in at least 3 criminal cases, placed him on the county's Brady list, and stated Vander Camp would no longer be called as a witness by the Deschutes County DA's office. The department requested a copy of the DCDAO investigation and received that on April 9th, 2025. The department determined that the conduct being presented to the committee violates the board's moral fitness standards as follows. For dishonesty. 1, Vander Camp was intentionally dishonest when he omitted previous employment or volunteer work as an Explorer Scout / Reserve Police Officer with the Los Angeles Police Department and a Reserve Police Officer with the La Mesas Police Department during his employment background investigation processes in 2004 and in 2008 with the Deschutes County Sheriff's Office. Item number 2, Vander Camp was intentionally dishonest when he omitted that he was terminated for a cause from his position as a Reserve Police Officer for the La Mesa Police Department. Item 3, Vander Camp was intentionally dishonest when he reported on 5 separate forums submitted to the department from 2008 to 2017 that he had not been discharged from a public agency. Number 4, Vander Camp was intentionally dishonest during his interviews with the independent investigator on both May 23rd of 2024 and September 18th of 2024. Number 5, Vander Camp gave false or misleading information while under oath regarding his education in 3 criminal trials, June 12th of 2013, October 3rd, 2013, and November 3rd, 2015 in Deschutes County, Oregon. Item number 6, Vander Camp omitted information regarding his previous work as a reserve officer in La Mesa, California, while testifying under oath in criminal trials on June 12, 2013 and November 3, 2015. Misuse of authority, the department did not identify sufficient information to make a finding of misuse of authority. Misconduct, item number 1, Vander Camp harmed the efficient operations of the Deschutes County Sheriff's Office and the public's trust by intentionally falsifying documents submitted to the department stating he had not been discharged for cause from a public agency, by providing incorrect information on his DCSO background investigation and impacting the DCSO's ability to interview previous law enforcement agencies regarding Vander Camp's performance and conduct as a reserve officer, and by giving misleading public statements and misleading statements to an independent investigator. Item number 2, Vander Camp threatened or harmed the efficient operations of the Deschutes County District Attorney's Office and the DCSO when Vander Camp provided false testimony while under oath that resulted in the DA placing him on the county's Brady list. Given this designation, the Deschutes County DA's office will be reviewing court cases involving Vander Camp's testimony to determine if any action should be taken to protect the rights of criminal defendants and the justice system. Vander Camp's dishonesty under oath discredits the law enforcement profession and the standing of the DCSO in the community. This dishonesty and potential reversal of justice found through court processes threatens the efficient operations of DCSO due to the negative impact of his dishonesty to the community. Chair?
Thank you. Scott Young for the record. It's my understanding that Sheriff Vander Camp's attorney, Randy Harvey, will be providing mitigation. Is that correct? And if it's correct, are you online?
That's correct.
Okay, thank you, Mr. Harvey. Now's the time to provide mitigation. You will be given 5 minutes exactly to provide a statement. At the conclusion of that 5 minutes, you'll be able to ask questions and you won't be able to ask the committee any questions. And we will stop you right at. So how would you like to be notified when you're close? I guess if you were in the room, we have a clock in here.
Yeah, if you'd just give me a heads up when there's about 30 seconds left. I do want to, before my time begins, note some objections for the record.
That's not the time for this. This is the time only for a mitigating statement.
Well, I understand that, but we informed Ms. McAlpine before that we had some objections that some of the individuals who will be participating on this committee should recuse themselves because they had predetermined this and having already made a decision before this meeting.
Mr. Harvey,
Members of the,
let me interrupt you for a second. This is the time for the mitigating statement. All of those other issues, this committee will make a recommendation, and that recommendation will be presented to the DPS. And I think other legal processes is where you would file those objections, not at this time. So I do want to make sure that we're sticking with our process, which is the same for everyone. And so this 5 minutes is for the mitigating statement and the mitigating statement only.
all right. Well, that's the first statement I'll make is we reserve the right to make our objections. We provided this committee, I'll begin my statement. We provided this committee with a significant written statement of our response to the investigation made by DPSST, prepared by my senior associate, Mr. Mittendorf, who had planned to make this statement today, but due to health considerations is not able to do that. The first statement of allegations has to do with dishonesty, that Mr. Vander Camp, Sheriff Vander Camp, was dishonest in terms of omissions that were made regarding his work for LAPD and La Mesa. Those statements of dishonesty are not factual. In fact, Mr. Vander Camp disclosed that information to the DCSO Sheriff's Department in his initial application. Was considered by the DCSO. That information is in our response. It was considered. Deputy Swift made that report to then Sheriff Stiles. It was in the Sheriff's Office files. Apparently, Mr. Ferris, who conducted the investigation, and then Sheriff Nelson didn't see fit to provide that information in the report to DPSST, which led DPSST to the false conclusion that he misrepresented facts, which is an untruth. DPSST was drawn to the conclusion that Mr. Vander Camp was intentionally dishonest when he admitted information or omitted to state that he was terminated for cause from a position at La Mesa. Again, that's not true. He was not terminated either for cause or otherwise from La Mesa. There are no facts in the record that that occurred. He was indeed not terminated for cause or otherwise from La Mesa. California, like Oregon, requires a procedure for that, including a Loudermill hearing. The law is specific in California. He was not terminated. There are no facts or evidence to support those allegations. Therefore, he omitted nothing in that regard. He was indeed not terminated. The report states that Vander Camp was intentionally dishonest when he reported on 5 separate occasions to DPSST from 2008 to 2017 that he'd not been discharged from a public agency. Again, he was not dishonest because he was not discharged. Again, there's no evidence that he was ever discharged, and therefore he could not be dishonest if indeed he was not discharged. The report states, allegation number 4, that Vander Camp was intentionally dishonest during interviews with independent investigator Ferris on May 23rd, 2024 and September of 2024 in reference to Ferris's report in discussing Vander Camp's experience over 30 years prior in regards to work he did as a cadet explorer with LAPD and his time as a reserve officer. Ferris reported that he was dishonest because he didn't consider that time as experience as a police officer. Apparently, DCSO agreed with Vander Camp because they required and didn't consider that as police experience when they required that he go to the Police Officers Academy. When he was hired by DCSO, Officer Swift didn't credit that as police officer service and required that he go to the academy. That's in DCSO's files. Ferris and Nelson didn't consider that and did not report that information in their investigation to DPSST. Number 5, the report states that Vander Camp gave false and misleading information under oath in 3 criminal trials on June 12th, October 3rd, and on November 3rd of 2015. The 2 previous were in 2013. The report is somewhat unclear about the facts that led to this determination. However, it appears these allegations relate to a curriculum vitae.
Thank you, Mr. Harvey. Your 5 minutes is up. I appreciate that. Okay, we're going to move to the next step where we're going to ask to adopt the record or return the record to staff. We're looking for a discussion on if we have any questions about the record. At the end, we'll be looking for a motion to adopt the record or to send it back for staff for more information.
Why am I being muted?
Your 5 minutes is up, sir.
That was 5 minutes?
That was 5 minutes. Yeah, I gave you a 30-second warning, and then I let you know when the 5 minutes was up, and then we muted you. Okay, back to, we're looking for a consensus, I'm sorry. Consensus to adopt the record. Any objections to adopting the record? I'm getting a lot of thumbs up around the table. Hearing no objections, we'll adopt the record. Now open up the case for discussion for aggravating and mitigating factors. Make sure that you state your name when speaking, and also when you're bringing up a point, discuss if it's aggravating or mitigating. And we will open the discussion. Not everyone at once, though.
Cotting for the record, I would open it up with, after reviewing the material, listening to the interviews, I found that there's an overwhelming amount of inaccuracies, responses, and statements that clearly, to me, fall in the category of moral fitness violation for dishonesty. I listened and read the mitigation. I find that the mitigation does nothing to sway me off of that determination, and I almost find that the mitigation adds to the aggravating nature of this case.
Thank you. Further discussion?
For the record, I would add that where there were inconsistencies or discrepancies, the usage of minimization was highlighted throughout this as well for me. Downplaying things that should have more seriousness or representation in somebody who starts this career at a very young age, that doesn't think it's important to document at a later time on a document, on a background check. And I think that there's proof in the material that minimization definitely existed.
Kevin Dresser, for the record, I would agree with that. It's a mitigating factor that it seemed by the material presented to me and that I read that this was clearly an extended service time as a reserve. I didn't buy off on this just being college credits and classes. It certainly was sufficient that he was performing law enforcement duties, both with regular officers, as typical of the reserve program, but also with some reserve programs where you were able to do solo work, and they had sufficient information that I reviewed that suggested that he did that on more than a few occasions. So to classify that experience as just a college credit type thing and not a traditional reserve program performing law enforcement duties just didn't. Just not there, and again, that minimizing that and trying to play on words and stuff just didn't resonate very well with me on that.
I just want to clarify for the record, you said at the beginning it was mitigating. Was that mitigating or aggravating?
Aggravating.
Okay, thank you for the clarification.
Livingston, for the record, I agree with everything that's already been said by others, but another aggravating factor for me was he made a point to talk about that time as unpaid work and really seemed to focus in on that as why he didn't include it in his background investigation, but he included the search and rescue, DCSO search and rescue time, which is also unpaid, and classified that as law enforcement experience, but then didn't do so for the work down in California. And so I felt that was aggravating. It really takes away that explanation as to why he didn't include it when he included the DCSO unpaid time as well.
Thank you. Scotty Young, for the record, aggravating for me is his continued assertion that by providing a college transcript with a class title is sufficient for a police agency to research and find out what exactly he was doing. I think the onus is on someone getting into law enforcement, and it would certainly be in your benefit if you've done things to prepare yourself, such as being an unpaid reserve. And I can think of no circumstance where you would not include that unless it was a negative experience. You also have to think of the time in the 90s when law enforcement was a much more sought after position. The candidate pool was much bigger, and and I just think the things you needed to do to get into law enforcement were different than they are today. So the fact that someone would leave that out accidentally or not tell on multiple occasions, to me, is just beyond logic to me. So I find that aggravating.
Mark Daniel, for the record, I have to agree on the aggravating circumstances, particularly around the time in La Mesa, California. He was obviously, based on the information we provided, a very active reserve. There was documentation that talked about a sergeant finding 5 citations in the basket, and the fact that he'd been involved in a pursuit, and a number of other things, and acting as a solo reserve as opposed to someone who's riding with another officer. That would be significant experience that one would really want to talk about on a application or in a process to be considered as a police officer. So I find it aggravating that was not included.
Patty Lofgren, public member, aggravating. Everything that's been said, to me, part of what was really difficult to see was the denial that he continued to make even after there was a reach out to La Mesa, reach out to LA, and the facts that they provided made it very clear that he was denying things that were obviously quite true. And that was very difficult for me, so that was an extremely aggravating situation.
Thank you.
Kevin Dresser, for the record, building on those things too, most of what I read with regard to being confronted with that information was not a solid denial of no, but simply I don't recall. And from my own personal experience, starting my career as a reserve police officer, I recall 100% of those things because it was so important to me at the time and so new to me at the time. And again, if you're seeking that, your Chair Downing said with regard to getting into law enforcement at the time, that's how you got in, is that prior experience of being a reserve. So unless it was a negative thing, you would be articulating all that training experience to continue and obtain full-time employment. So, but again, going back to my point that most of his things were not solid no's and denials, they were simply that he just didn't recall, which I had a hard time believing.
Thank you. Scotty Downing for the record. Also, his CV, the written information in the CV, and then to essentially blame that a third party writes this stuff. It's just really beyond belief that you would turn in a resume that could say really anything if you don't read it and proofread it. And so to say you have a master's degree from a university you didn't attend or a bachelor's degree from a university you didn't attend, and to use the excuse that someone else wrote it, it just doesn't, it's beyond logic to me. So, and I think if you read the materials that were provided, I believe the correct information was in there at one point, and it just continued to evolve over time, which seemed to provide a more robust educational experience that just wasn't there. We just don't have documentation for it.
Mark Daniel for the record, and just follow along with that. I mean, there are multiple CVs that are in this document that we've been provided from year after year or a number of years, and they change multiple times through there. So the college experience is either there or it's not. There might have been one that I read that was actually reasonably accurate based on his actual education, but they kind of went back and forth and changed year to year.
Copy for the record, I would add regarding the CV that although it is possible to make mistakes on a CV, what is really hard to understand is how you then go in and testify under oath to the educational background. So really the mitigation provided holds no standing when you're under oath and testifying verbally under your own experiences. Additionally, I find it aggravating when I look at the review from the Deschutes County District Attorney's Office and this then subsequent Brady determination.
Rob Wood for the record. To expand on something with the job and volunteer, and the reason it wasn't supplied on numerous applications was it because it was college credits that he was paying for. Yet experience, as you've all brought up, is very important when you're a solo reserve. However, he had no problem sharing that with his field training officer during the Bend FTAP, because that was used as a consideration to accelerate his FTAP program. So I find that interesting that it wasn't disclosed as experience because it was college credit, yet it was disclosed to his field training officer.
Thank you. More discussion? Any discussion from anyone online, aggravating or mitigating? Hearing none, I want to review what we've...
I'm Cindy Park for the record. I recorded no mitigating statements, aggravating statements. There's an overwhelming amount of inaccuracies in the statements. The written mitigation is aggravating. There's inconsistencies or discrepancies in use of minimization. I made a point to talk about unpaid work, but didn't include did include the DCSO unpaid time. It takes, I can't read my brain. Not including unpaid work from La Mesa, but including unpaid work from DCSO. Continue that college transcripts is sufficient in background information to DCSO. It was obviously a very active reserve, did solo work, significant experience and would want to be a part of the hiring process unless it was in a negative experience. Denial, even after information from La Mesa was received, stating, "I don't recall," when asked questions about reserve time. No solid answers other than he did not remember. CV, the written information blaming a third party with educational degrees to schools that were not attended. Also aggravating multiple CVs in the documents, then they're changed multiple times year to year. In a CV, it's possible to make mistakes, but testifying under oath to those CVs is questionable. Review of the Deschutes County District Attorney's report and subsequent Brady designation of Sheriff Vander Camp. And that experience as a reserve officer was used as a consideration in the field training officer program, but not in the background.
No, not at all. Does that reflect? Capture everybody's? See that?
Mr. Chair.
Anyone have anything that was missed? We'll now open discussion about whether or not there is a moral fitness violation. We have the following options. We can affirm the moral fitness violations that were identified by DPSST, which are dishonesty and misconduct. We can modify, we can make changes, or we can negate, which would remove it altogether. So we would call for a motion to affirm, modify, or negate the moral fitness violations as identified in the report.
Kevin Dress, for the record, I move that we affirm the moral fitness violations that are in the report.
For both dishonesty and misconduct?
Yes.
Thank you.
Livingston, a second.
Thank you.
Right, we are voting on a motion to affirm the moral fitness violations as presented. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood.
Aye.
Motion passed.
Thank you. We'll now look for a motion to either take action or take no action.
Rob Wood, for the record, I make a motion that we take action.
Connie will second.
All right, we are voting on a motion to take action. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend?
Aye.
Committee Member Wood.
Aye.
Motion passed.
Thank you. Next, we will call for discussion and a motion regarding the amount of time of the ineligibility period. Do you want me to go over it, or do you want to?
Chair, I'm happy to Captain Calvin for the record. Because this includes dishonesty, the recommendation can be up to a lifetime.
If you do make a recommendation, it's just a reminder to, if you pick a amount of time, to follow up with some discussion on why you're picking that amount of time. So we can have a conversation about it.
Livingston, for the record, I'm recommending lifetime. I think that in this line of work and the level of dishonesty and inaccuracies throughout, and then the lack of accountability or any kind of remorse or acceptance of whether he wants to say it's a mistake or not. There's like no ownership for it. It's just basically giving blame back to others, and so I was not moved by any of the mitigating information provided, and and the level of dishonesty throughout the years is, and the testifying in court, I think it just raises to that level in my mind.
Barrett, I would second that, and with everything that she said, but with additionally adding that him and or his attorneys took steps to try to keep some of this quiet, up to and including filing a temporary restraining order application against the DCSO to prevent the release of the La Mesa documents regarding some of this stuff. The not signing of the disclosure agreement. So not only were there inconsistencies, accuracies, minimizations, but there were steps taken to hopefully keep some of this from coming out as well.
Public Member Lofgren. I'm just speaking as a public member. In reading through these files, the number of factors that, in a negative sense, gave me a sense that this is not a person who would make me feel safe in my community. This is not someone who I would want to be responsible for law enforcement in my community. It left me with a sense of fear and trepidation, and so I just totally agree that I would not want this person to be in this position.
Thank you. Scotty Downing, for the record, I will agree with what everyone said, but there's several committees and folks here at the Academy who are responsible for weeding out, and we've gone through a lot of procedures to weed out folks who come from other agencies and historically been able to hide their acts at previous agencies, and oftentimes another agency will hire them, and so there's been safeguards put in place legislatively, administratively, and committees that are trying to identify these situations exactly like this, where someone has a history from another state, and there was multiple opportunities to provide that information on multiple different forms, and Sheriff Vander Camp just did not. And so it did get exposed eventually, and so here we are. So I agree with what everyone else has said, and if there's no other discussion, we have a motion and a second.
We are voting on a motion for a lifetime ineligibility period. Chair Nowning?
Aye.
Vice Chair Conning?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Jovic?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Thank you. We're going to take a 5-minute break. is that?
Book 1.
I can say book 1.
Tab 2.
Book 1, tab 2.
Tab 2 of the cases. 4, yeah.
Okay. Let's go to the name.
Yes, yeah. Yavor.
And I believe, and she okay, yeah.
Yes.
Okay, and I think Melissa is doing this. Are we back? Is everyone ready? Okay. Go ahead. Thank you.
Thank you. Melissa Lynn for the record. Good morning, Chair and Police Policy Committee members. The department opened a professional standards case for Almadina Yavor based on a separation from employment from the Columbia River Tribal Police Department. The agency reported that Yavor's resignation during an investigation into allegations that she was in a romantic relationship with a known felon offender. An investigation into the allegations was conducted, and there were sustained findings that Yavor violated the agency's policies, finding that the community was aware she was having a relationship with a known offender, which was harming the standing of the agency in the community. Her 20-plus meetings with him on non-official business equated to not performing the duties of her position in an efficient manner. Her use of law enforcement data systems for personal reasons threatened the agency's access to the information system. The department found that she violated the standard for misuse of authority by running the license plate of a vehicle owned by her romantic partner after she was questioned about her relationship with him. Yavor misused her position to intentionally retrieve information from the law enforcement data systems for her benefit. For misconduct, Yavor's romantic relationship with a known offender threatened or harmed the efficient operations of the Columbia River Tribal Police Department. Her romantic relationship damaged the standing and trust within the community. Her utilizing of the agency's time set aside for her to conduct patrols to foster a romantic relationship. She neglected her duties to foster that relationship, which impacted the morale of the officers who were performing their duties efficiently. Her misuse of the law enforcement data system to look up information on the known offender threatened the agency's access to the system, which could diminish their day-to-day operations of the agency, that they were sanctioned. Were they to be sanctioned for her actions. The department is seeking a vote to affirm, modify, or negate the findings, and Ms. Yavor is here remotely to provide a verbal statement to the committee.
Thank you, Melissa. Ms. Yavor, can you hear me?
Yes.
Thank you. My name is Scotty Nowning. I'm the chair of the Police Policy Committee. Now's the time for your mitigation. You will be given 5 minutes, and 5 minutes only, to provide a statement to the committee. How would you like me to let you know when you have about 30 seconds to go?
You can just, yeah, you could just let me know when I got 30 seconds.
Okay, and you can pick a time if you'd like a minute. It's up to you, really.
Yeah, maybe it won't take the whole 5 minutes.
Okay, I appreciate it, and I will let you know when you have about 30 seconds to go, and we will stop you at 5 minutes. After the completion of that, you won't be able to ask us questions, and we won't be able to ask you questions. You're welcome to stay online and listen to the rest of the conversation about your case.
Okay.
And whenever you're ready, we're ready.
Yeah, so I did begin a relationship with a person with a criminal record, unbeknownst to me that it was against department policy. I got hired with Columbia River Intertribal Police Department when I was, I believe, 23 or approaching 23. And I was a naive and young officer. Those 20 plus meetings with him, though, that was due to me patrolling the in lieu sites that he was fishing on. And it wasn't just with him that I conversed. It was with members of the community. You know, I spent time on the in lieu sites speaking to the community members a lot, not just running from in lieu site to in lieu site. I actually spent time on the sites. Yes, I did begin a relationship with him, and I did not disclose it due to my own naivety, I guess you could call it. But I was never once dishonest. I never lied, cheated, or stole, anything of that nature. I began a relationship with a person with a record, and we all have pasts. I guess the accusation of me running his license plate, yes, I ran almost every license plate that was on the in-lieu sites that was within my scope of duties. I ran him before we got into a relationship. I ran almost everybody that I came in contact with. That's just a basic officer safety concern for me. That's all I have to say for now.
Okay, thank you, I appreciate it. Okay, now we need to have a consensus to adopt the record or return the record for more information. Getting a consensus in the room, any objections, online or otherwise? Hearing none. We will adopt the record as it is presented. We will now open up for aggravating and mitigating factors. Reminder to state your name and whether or not it's an aggravating or mitigating factor.
Member Townsend, aggravating. My concern is that this was reported by a member of the community, a tribal member of the community, and that the relationship may not have been disclosed or discovered had not been brought forward by that member of the community, and so I'm concerned that this may not have come to light had that not occurred.
Thank you.
Michelle Duncan for the record. In reading this, her agency even gave her the opportunity to discontinue the relationship, even though she stated she didn't know it was a policy violation. She was notified at that time at least, and still chose to continue the relationship with this person.
Barrett, for the record, aggravating that she did appear to use our systems for her own personal gain and knowledge, but mitigating would be that that does not appear to be a pattern of it. It might have been a one-off. Two, to her verbal testimony that she then also ran him specifically.
And Chair Brandler, for the record, in alignment with that, the record states, is in conflict with what she testified to, that she had ran the plate before their relationship, if that's what I heard correctly. The record here says that after the relationship began, that the license plate was run on February 14th of 2023. After she had been questioned about the suspicion of violating the relationship policy. So there's some conflict there in the mitigating testimony today.
Thank you. Scotty, now for the record, aggravating as well as her testimony. I believe the car, according to our record, the car was registered at her residence. So when she ran it, so it would have been after they were certainly in a relationship.
And Barrett, for the record, this just kind of is a food for thought conversation. Everybody gets into law enforcement, I think, gets into it for certain reasons, and we know what our ultimate goal is to keep people safe. That whether it's naivety or you read the policy and you know it, affiliating yourself with felons should be something that should be at least pop onto your radar as is not allowed, or to at least then start asking some questions. So I think I find that a little bit aggravating with the verbal explanation.
Mark Daniel for the record, I also under aggravation, I think it's clear that, she has attended DPSST, she went through the basic police academy, there's discussion about who you should and who you shouldn't be around in the basic academy, and certainly going through FTEP, officer safety, establishing those relationships and how those can compromise, not to mention the fact that the agency is a Lexipol agency and it has a policy that specifically outlines this conduct, and number two, that she would have read that policy and acknowledged that in the electrical policy system.
Anything else aggravating, mitigating? Let Melissa catch up on writing.
Mr. Chair, I have one mitigating factor, which was that her use of systems for her personal benefit did not appear to be a pattern. And for aggravating, that her relationship was reported by a member of the community, and had that member not reported it, her relationship may never have come to light. The agency gave her the option to continue her employment and the relationship with the known offender, and she chose to continue the relationship. It did not. She did appear to use the systems for her benefit, and she ran his information specifically. Records indicate that after she began the relationship with the offender, she ran his license plate. The car at the time was registered at her residence and would have been after their relationship began. Affiliating with known felons should be something that officers question about themselves and their and what they're doing in law enforcement. She attended the Academy FTEP officer safety courses, and it would have been something that was covered in those policy that she read and would have been required to acknowledge that her relationship needed to be disclosed. Mr. Chair.
Thank you. Looking for a consensus that this has captured our aggravating and mitigating. Any objections? Thank you, Melissa. We'll now open discussion about whether there was a moral fitness violation. We need to affirm, modify, or negate. And in this case, it is misuse of authority and misconduct, which the department has identified. We'll be looking for a motion on that.
And Chair, Captain Calvin, for the record, that would be 3 to 10 years for either one of those, your range.
Thank you.
Connie, for the record, I make a motion on both misuse of authority and misconduct.
And I will second.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wolf?
Aye.
Motion passed.
We will now look for a recommendation on to take action or not. And we will need a motion to take action or to not take action. You can discuss, or someone can make a motion.
Member Townsend on the motion. Take action.
To take action. Chair Nowning, I'll second.
Voting on a motion to take action. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren? Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
We'll now have discussion and motion regarding the amount of ineligibility period. And as Catherine McAlpine stated, 3 to 10 years, is that what we're looking at?
That is correct, Chair.
And apparently it would start from separation of employment February 22nd of 2023. If you make a recommendation and we call for a motion, please state what your recommendation is and justify why you're picking that amount of time.
Michelle Duncan, for the record, I'd make a recommendation for 10 years for each violation. Partly because of her statement here today. She, I don't feel, was taking full responsibility, even though she could have. This would have been her opportunity. You know, she was given, now this is the third opportunity in my mind to take full responsibility for her conduct that could not only compromise safety of others, deputies, officers, whatever, out on the street, but also just the public trust and that kind of thing.
Member Townsend, I would support what the sheriff just had to say for the time limit. I'm not convinced by, especially by her testimony today, the comment that she ran everyone in the community. I'm not convinced that if she were to have access to databases in the future, that inquiries on those systems would be just for criminal justice purposes only. So I would support what the sheriff had to say.
Chair Downing, for the record, I was leaning toward much less time because of her small amount of time in the career field, and it seemed to be a one-off. But to echo what you said during her own testimony today, she still hadn't taken responsibility for what she did. And you know, looking at her training record, she had been trained in LEDs multiple times, and that's a very core function of LEDs, and a very well understood that we just can't do that. So I would agree with everything's been said.
Barrett, it didn't click to me until I think Sheriff Brandenburg said it. If that car was in fact registered to her at her house, she would have known that. She wouldn't have needed to run the plate. So close after her interviews and then before leaving, which is a clear and just clear misuse of that system 100%. So that didn't even click until you said something. So I'd have to agree.
Probably for the record, I put less weight on the LES violation maybe because I don't understand. If I understood what she ran the plate for registered owner, but did she run the registered owner? Was she looking to verify that in fact it was registered now at her home address, or was she running the person that she was having the relationship with? So I put less weight on that, and I was leaning towards what our chairman said for less time, but I also agree with you with her testimony today, actually added to an aggravating situation, but not taking responsibility for, as you mentioned, the third time.
Barrett, for the record, when those systems can get audited, if you've got one bad actor using it in your department for not lawful purposes, the entire agency can lose access to that search. So that's where it's a compounding problem, and it's going to cause a much larger issue for the agency to do their job if they don't have access to it. So I think that's why we're all putting a lot of weight on that.
Thank you for that.
And Michelle Duncan, for the record, for me, there is some weight put onto the LEDS violation, but it's her testimony today of when and why she ran it that is why I think this is a more egregious time, or more serious time that we should be imposing. Because as Sheriff Brandenburg pointed out, she's saying that she just runs everybody, although she was clearly already told about this relationship before she ran it. So yes, the LEDS is an issue, and it is an issue for the agency, but I think what I feel is the dishonesty in her testimony is more the factor that I'm considering.
Patty Lofgren, public member. For the record, just a clarification question, Sheriff Duncan. When you said 10 years per violation, does that mean 20 years?
Yes. I think unless it's I don't know if it's concurrent or.
No, Captain McCoppin, for the record, our max is 10 years, period.
Okay, 10 years. Thank you.
We have a motion in a second, right?
Yeah.
I know, yeah, I'm sorry.
Yeah.
We appreciate all the discussion, of course, yes.
Okay. So we are voting on a motion for a 10-year ineligibility period. Chair Downing?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend? And Committee Member Wood.
Aye.
Motion passed.
Now we just go right down the order, starting with Clark.
Moving along, Randy Clark.
Share if you want, I would do the cover sheets. She may be
Ms. Moore, you're free to go if you would like. Yavor? No, I'm saying it right. Medina?
Yes, thank you. I would like to say I did take responsibility, and I do take responsibility for my actions in this case. I don't know how it came across that I wasn't taking.
Thank you. Okay, our next case, Randy Clark. It's Melissa again. Thank you.
Thank you, Mr. Chair. Melissa Lynn for the record, policy committee members. The department opened a professional standards case for Randy Clark based on his separation from the Central Point Police Department. The agency reported that Clark retired during an investigation into allegations that he was continuing to contact his former girlfriend after repeated requests to cease contact. An investigation into the allegations was conducted, and there were sustained findings that Clark failed to follow a lawful order to stop communicating with his former girlfriend. Clark gave misleading statements that misrepresented or omitted material information during the investigation into his conduct. Clark made statements to coworkers and subordinates that were misleading or disparaging that disrupted the efficient operations and good order of the department. Clark continually attempted to contact his former girlfriend after being told not to contact her. Clark exhibited alarming and impulsive behavior in his repeated contact with her. And Clark utilized his department-issued phone to attempt to contact his former girlfriend after being told not to contact her. The department found, after reviewing the information, that Clark violated the board's moral fitness standards for dishonesty, misuse of authority, and misconduct, finding that Clark intentionally gave misleading statements during his interview during the internal investigation. For misuse of authority, Clark used his department-issued phone for his benefit to attempt to contact his former girlfriend on several occasions. And for misconduct, Clark harmed the efficient operations of the Central Point Police Department by negatively impacting the morale and good order of the agency by telling coworkers while he was on administrative leave that he was being treated unfairly. Clark harmed another person by making repeated attempts to contact them when they wished not to communicate with them. Clark's appearance at his former girlfriend's place of employment harmed the efficient operations of her place of employment and made her coworkers feel uncomfortable. The department is seeking a vote to affirm, modify, or negate the department's findings, Mr. Chair.
Thank you. We'll be looking for a consensus to adopt the record or to return this to the case to staff for additional information. In the room, we have a consensus. Any objections? Seeing none, we'll adopt the record. We'll now open the discussion for aggravating and mitigating factors. Reminder to state your name and whether or not your factors are aggravating or mitigating.
Kevin Dresser for the record. You can jump up and correct me if I'm wrong. Some of the mitigating things is some lacking of detail in the totality of the investigation. When we talk about disparaging comments made to his subordinate coworkers, it's not other than unfairly thing. It's not specific. They can go back and interview specific members to say what those conversations or specific comments were. That sort of bothered me. Obviously, the former girlfriend not wanting to participate with the criminal investigation. Another point that I noted was that it was described as making a scene at her place of employment, but that wasn't really described other than the word scene, and there was actual specific sentence that said that Clark was not belligerent or confrontational, and he was there for 5 minutes and apologized and left. there's just different things in here that just lacked a lot of detail and a lot of inferences without supporting detail to some of these statements.
Thank you. Just cutting down for the record, I would say mitigating as well is the girlfriend even admitted they'd been together for 10 years and this had happened off and on where they had broke up and then they get back together and it seemed like one of those relationships that's maybe, well, I don't know why this time was the final time, but she said she's not worried for her safety in any way, he's not violent, she didn't want to pursue criminal charges. I found it interesting, her route, and I do understand there's a lot of dynamics to domestic violence relationships, but I just we don't have that information in this record. And so for her to take this route of having the police department give a lawful order to not have contact with folks is a very interesting route when the court system is set up specifically for these type of cases, and she chose not to take that route. And so I think if she would have filed a stalking order or if she would have wanted to pursue criminal charges or anything like that, and this would have been a violation of that, it would hold a lot more weight. But the police department getting involved in personal relationships, I'm just not even sure where that line is. Where that line is okay.
Michelle Duncan, for the record, I kind of had some of the same concerns of can they even, as an employer, intercede in their personal life when it's, at least at this point, not a criminal matter, and then rely their termination on that order. I just felt like they chose the wrong lane in how to handle this conduct, and I don't know that I found anything that rose to the level that they described.
Sheriff Bradford, for the record.
No.
I think that the agency can restrict behavior of folks, and I think it's upon us as leaders of agencies that when there are investigations going on, and folks are, particularly in domestic violence relationships where it is messy, and we put the onus on folks who are the subject or the victims of domestic violence to do certain things. That myself as an employer, if I have someone coming to me and they're exhibiting concerning behavior that they refer to another police agency to do an investigation into potential criminal conduct, which is stalking, that we have every right to restrict their behavior of the employee during that time. So once that is done, I think that it's difficult for us to govern behavior of folks, but certainly during this time, I think it's appropriate.
Robert, for the record, that's exactly where I was going. And she felt it emergent enough to purchase a car and purchase a home without letting him know. So there was something going on there that she didn't follow the route through the courts, which would have taken a long time. She took a shortcut and said, let's stop this immediately and contact your employer. Whether it's correct or not, I don't know, but I think in her state of mind, this is what I'm guessing, she took that route.
Kevin Dresser, for the record, I don't like guessing. I like details. They did an investigation. They could have done that. They allude to this DV history, but we have no information on it at all. So that's my problem, is they allude to many things, but they don't have any support for it in their investigation, at least the materials presented to us.
For the record, I would agree with that. So if we took the guessing component for the DV off the plate and just focused on the stalking, I'd say that we definitely have multiple stalking-like behaviors, not just one occurrence, a couple occurrences, phone calls, blocking one phone, so he starts dialing from another. In a meeting with his chief and two captains, he was actually told that his behavior met the definition of stalking. So to Sheriff Brandenburg, that might have been their cue to get another agency involved, because also it was domestic violence. Victims don't have to cooperate. They don't have to be participatory. That's when us as law enforcement are supposed to step in and protect these people. So yes, there's some guessing, but if we wanted to take that out, we could focus on stalking, and that is, I think, in my opinion, that is here.
Sheriff Brandenburg, I agree with what you said. And the burden on the employer is preponderance of the evidence, not beyond a reasonable doubt, which is what courts use. So had this case gone to the courts and, they have to prove beyond a reasonable doubt that this occurred, as an employer, it's preponderance of the evidence, which is 50% plus a feather.
Livingston, for the record, aggravating for me was just that he's a 30-year law enforcement officer and knows what stalking is, and that he can't accept or understand that his behaviors were going down that path, and he just kept using the excuses, we're just trying to work out our relationship. And it was clear that it was over. And regardless of the fact that, yes, they'd kind of gone back and forth, she took these extra steps. He should have clearly known this was over, and he kind of alluded like he didn't know what that meant, and 30 years in law enforcement, you know what it means.
Patty Lofgren, for the record, aggravating to me, it seemed like when he crossed the line was when he used the police-issued phone to contact her, because she was clearly establishing no contact issues. And so, to me, that was where it kind of went over the line.
Scott down for the record, and I think again, it's agencies have different policies on calling your spouse or your loved one with your work phone, and I think it's probably very common that folks call their spouse or their loved one with their work phone to say, I'm going to be late, or I'm going to do this, or I'm going to do that. So, like I said, I just what I find in this case, I need a lot more information. There's a typical stalking behavior is a lot of contact in a pretty short period of time, and the person's, especially when they know this person, they know their routine. This is actually taking place over, it seems like a month, where it's days in between the person showing up, and I just don't know enough about their relationship. I'm just listening to what she's telling the investigator. And to your point of she bought a car and a house, you can get a stalking order. The police officer can issue a stalking citation today. If someone comes in and says, I'm being stalked, and gives you evidence of that, and they want to pursue that, I can issue a stalking citation today. You'll be issued a court date, and a court will hear it. It's not a long process, because stalking is dangerous, and we know that. So the fact that she didn't not want to go through that, in fact, she said, I want him to keep his job. I think he's a good police officer. I just want him to be happy. It's just difficult for me because there's so much information I don't know, and we're having to kind of fill in the blanks.
Michelle Duncan, for the record, I think additionally she made a statement that she was not afraid of him harming her. She just wanted the relationship to be over. And just clarifying on the timeline, she came in 4 days after she moved out saying, hey, I don't want any contact with him, to his agency. They then issued the order. I feel like they should have, if they felt like it was a stalking issue, then, and I don't know that it would have risen to that level at that time, that now giving him an order to not talk to a girlfriend, that he's worked out things, like I'm trying to give some mitigation to his mindset at the time. And then it was a week, 3 weeks later that it was finally given to Medford. I think it should have been, if that's what the agency's mindset was, they should have turned it over to another agency for criminal right there. I just think that was the more correct path.
Patty Lofgren, for the record, I am now going to backtrack to what Officer Dresser said, because based on what I've now reread, it's possible that he was using a phone number that she knew. I was thinking it was a phone number that she was not aware of, but so now it's unclear whether he was calling her with a number that she would have recognized. Oh, that's his work phone. So I'm backtracking and saying, as Officer Dresser said, not enough information.
Any more? I feel like we're kind of back where we started. Okay. Any more aggravating or mitigating factors? Anyone online? Aggravating, mitigating factors. Quiet group online today.
I believe we only have SAC Olson online.
Oh, all right then. That's still a lot of names. If you can read, I'm gonna be very impressed with you if you can.
All right, for
Let's see.
mitigating, I have that the investigation was lacking details in its totality, and we don't have quotes for a number of the allegations. There were inferences without details. That we are guessing about domestic violence, and there is information to allude to that, but there is no supporting information. It's common for officers to contact family on their work phones, and we don't know enough about the situation, but she did indicate that she wants him to keep his job. The girlfriend indicated that she was not afraid of being harmed by Clark. She just wanted him to stop contacting her. And if the mindset from the agency was that what he was doing was criminal, they should have turned it over immediately to an agency for an investigation. There was not enough information to say that she was calling, that he was calling from a phone number that she did not know when he was using his work phone. It was questionable whether an agency could interfere with a personal matter and base separation and investigation on a personal issue. The girlfriend indicated that it happened multiple times in the past, their breakup, and that she was not concerned for her safety. It was an interesting route for her to go to the agency instead of going through the court system, which is set up for these types of issues, but instead chose to contact his employer. And then for aggravating, agencies can get involved when there are allegations or concerns about domestic violence. His agency had a right to restrict in this situation because it looked like he was stalking. She purchased a car and a home without Clark knowing. If we remove concerns about domestic violence and just look at it as a stalking issue, we do have enough information on his behavior to meet the criteria for stalking. Victims don't have to participate in criminal investigations. The burden on the employer for their investigation is a preponderance of the evidence, which is just slightly over 50%. He had 30 years in law enforcement and knows what stalking is, and didn't appear that he could accept that his behaviors were over the line. He alluded that he did not know that what he was doing was wrong. He crossed the line when he used his police phone to contact her, which I think was perhaps taken back or changed in a mitigating, and made to be mitigating. I think that was all I had written down. Please let me know though if I did not capture something, Mr. Chair.
Thank you. Do we have a consensus on our identified aggravating and mitigating? Anything missing? Any objections? Okay, so we'll discuss whether or not there was a moral fitness violation. We need to either affirm, modify, or negate. And there are all three. Chair Downing, for the record, I'm inclined to make a motion to remove dishonesty and potentially misuse of authority because I don't have enough information, and affirm misconduct because I do believe there was some level of misconduct because he had been told by his employer to stop and did not.
So you're making a motion?
I don't know. Throwing it out there. Yeah, it's,
We got a second.
all right, well, yes, it's a motion to, right. I feel like Denisha Barrett has something to say, though.
Oh no, I'm listening
Okay.
to, I didn't hear, what's the exact motion?
I'm going to make a motion to affirm misconduct and we'll modify this to take out dishonesty and misuse of authority and affirm misconduct.
Can do that.
Yes.
Second that.
Thank you.
All right, we are voting on a motion to modify the moral fitness violations to remove dishonesty and misuse of authority and affirm misconduct. Chair Downing?
Aye.
Vice Chair Connie?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend? And Committee Member Wood.
Aye.
Motion passed.
Okay, now we have to decide, do we want to take action or take no action? And if we take no action, we do include why no action is recommended. We will take discussion, or a motion to take action or not take action.
Robert,
Would you look like you're ready
can
to?
staff just remind us what the misconduct, the term would be and when it would commence?
I can, Captain Comfort for the record, misconduct is a 3 to 10 years. And the time frame, I believe we got at the end of the report, would be June 15th of 2022.
Robert, for the record, so if we take action, we cannot approve a 0 year, we have to go with a minimum of 3.
Almost like watch for the record, you can, I'm sorry.
Well, you started afterward, but if you did a 3-year, it would be June 15th of this year would be the 3-year period. So essentially, we're almost time certain, correct. So it's as close to 0 as we can get, correct?
3 years is the minimum.
Is the minimum.
But I believe in the past that we have decided to take action and then have 0 years of revocation. It might be.
I think it was affirm and take no action.
Right.
Yeah.
So we could take no action if there's a motion to take no action, or we could take action and then discuss about the amount of time that we want to take.
Barrett, for the record, can I just add one more little piece of discussion that I was sorting through? I don't know if it would be aggravating to me. When he was interviewed about this, at one point he told his former girlfriend not to tell anybody about it. And when questioned about why he told her not to tell anybody about it, his mind was even tracking with the fact of he thought that if the chief contacted Medford PD, or if there was a restraining order or a stalking order, that he could get in trouble. So he was even tracking that his behavior was leading that way, whether we have the supporting documentation or not. So if I'm going to make a motion, it's going to be that we do take action, but I could go towards the lower for it. The investigation aside, we have to make a decision based on what we have, and that comment alone leads me to be like, no, I'm going to recommend we take action.
And Dresser, for the record, to follow up on that, when he walked into that meeting, he asked if he was being fired. That initial meeting, so that would also go to what you just said, that he was sort of tracking on that line for that's how he walked into that first meeting when he was called in.
So is that a motion to take action?
Bear for the record, if nobody else wants to add to that, I would make a motion that we take action.
Livingston, second.
All right, we are voting on a motion to take action. Chair Nownie?
Aye.
Vice Chair Connie?
Aye.
Committee Member Barrett.
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Daniel.
Aye.
Committee Member Dresser.
Aye.
Committee Member Duncan.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lofgren.
Aye.
Committee Member Townsend. And Committee Member Wood. Motion passed.
Chair Gunning, for the record, we now need to have discussion and motion regarding the amount of time that we've already discussed. It's for 3 to 10 years from June 15th, 2022 would be the start date. So if you make a recommendation or a motion, just explain why you're asking for that amount of time.
Barrett, I would make a motion for 3 years because of the caliber of investigation coupled with statements from the female half of not fearing for her life, not fearing for safety, not wanting him to get in trouble, and things of that nature.
I second that.
Thank you.
We are voting on a motion for a 3-year ineligibility period. Chair Nally.
Aye.
Vice Chair Conning.
Aye.
Committee Member Barrett.
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Daniel.
Aye.
Committee Member Dresser.
Aye.
Committee Member Duncan.
Aye.
Committee Member Livingston.
Aye.
Committee Member Lofgren.
Aye.
Committee Member Townsend. And Committee Member Wood.
Aye.
Motion passed.
Item number 6, third book.
What name?
England?
Oh, yeah.
Jeffrey?
I misspelled this all. Kindly. But everyone's at Jeffrey Kynan. Melissa, you can go ahead.
Thank you. Melissa Langbotcher for the record. Policy committee members, the department opened a professional standards case for Jeffrey Kenlin based on his termination from the Dallas Police Department. Kenlin's termination followed his placement on the Wasco County District Attorney's Tier 1 Brady list. The DA's office placed him on the list for conduct occurring in 2011, which they had not previously reviewed. The DA's office found by a preponderance of the evidence that Kenlin made false statements to his supervisor and a fellow officer regarding the need to use a city vehicle and where he was staying during a training, which led to him violating the agency's policy for truthfulness. Kenlin used a vehicle under false pretenses and used the city's resources to travel between Eugene and Salem, which was part of that policy violation for truthfulness. Kenlin was untruthful and lacked integrity, demonstrating disregard for policies and standards of proper police practices. Kenlin's violation of the policy for truthfulness came just 2 months after he was reprimanded for actions concerning a pen gun, showing a persistent dishonesty following an administrative action. Following Kenlin's being placed on the Brady list, the DA's office hired a contractor to conduct a review of the cases that involved his testimony as a witness, and the review recommended a dismissal of 30 cases that were that involved a felony conviction, 55 that involved misdemeanors, and 8 for violations, and 6 for contempt of court. After he was placed on the Brady list, his agency terminated him. The department found that Kenlin violated the board's moral fitness standards for dishonesty and misconduct. The department found that Kenlin was intentionally untruthful in his request to use the city vehicle to travel to his cousin's home while attending a training in Eugene. Instead, he traveled to Salem for personal reasons. Kenlin intentionally made false statements to his supervisor and a fellow officer regarding his whereabouts during the training. The department found for misconduct that Kenlin's conduct resulted in a highly publicized review, which reflects poorly on law enforcement profession, and the recommendation to dismiss criminal court cases, including 36 felonies, creates a potential risk and negative impact to the victims and the community. As such, created an inefficient operation of the Dallas Police Department and the Wasco County Sheriff's Office, or District Attorney's Office. The department is seeking a vote to affirm, modify, or negate the department's findings. Mr. Chair.
Thank you. Before we ask for a consensus to adopt the record, I have a couple of questions. Is there more information about the pen gun? I have a lot of questions about this case. We do have a lot of information provided, but there's a couple things I just wanted to know if there was no more information available.
Correct. Yes. We didn't receive the pen gun investigation.
Okay. Yes, it's referenced, but
Yes.
I'm fine to go on without it. I was just wondering where it was and what it said.
I think there might have been a memo that essentially said that he was reprimanded, but not an investigation or full details of exactly what that was about.
Correct. My concern was was also around truthfulness, whereas as was the second incident, was around truthfulness, and
Yes.
neither of them apparently rose to the level of concern with the department at the time. With all that being said, I believe I have enough information. Anyone, other discussion or consensus? Adopt the record. Appears we have a consensus. We'll adopt the record. Discussion of aggravating and mitigating factors. We'll open up the case for discussion. You're going to state your name and if you're aggravating or mitigating. Chair nodding for the record. I will start aggravating. This is just dumb. It's just a dumb reason to be untruthful, to take your department car and travel hundreds of miles, probably over a couple of days, to stay at a hotel room with someone. It's so unnecessary, and I just find it when we're in these situations, you just shake your head of why would a police officer do this, and why in our career field would you do that? And I think it's aggravating that the level of effect it had on the cases in his county is extremely aggravating. I could go on and on.
Mark Daniel for the record. Aggravating, it's abundantly clear how manipulative he was to get his own way, and this was a premeditated thing, meeting this person in Salem and making up reasons why he couldn't stay in a hotel room with one of his fellow employees while he attended training in Eugene. So the premeditation really got me. Being manipulative of the chief of police and anybody else there in the department, I just had a real problem with.
Public member Lofgren, for the record. Once again, as a public member, reading about the degree of dishonesty and misuse of materials, it just, to me, once again stood out that this was not someone that I think should be representing me in the police force. The level of misinformation and dishonesty and misconduct was just over the bar.
Thank you. Anyone else?
Rob Wood for the record. I'm going to just expand on what you said, aggravating. I think it's aggravating in all sensitive definitions of the word aggravating, with the number of cases that were recommended to be dismissed, the number of cases that were recommended to be expunged, the records. The DA obviously thought this was extremely aggravating, and as jeopardizing the public, this has real impact on everyone.
Thank you. Any mitigation? Hearing none, Melissa, if you want to.
Thank you, Mr. Chair. For aggravating, I have that it was a dumb reason for him to be untruthful, and it was very unnecessary. The level of impact on cases in the county was aggravating. It was clear that he was manipulating and had premeditated to meet another person in Salem during the training. The degree of dishonesty and misuse of resources means that he is not someone who we would want in the profession. It was aggravating, the number of cases involved, the number to be expunged. The DA thought it was aggravating and jeopardized the public, and the issue has an impact on everyone, Mr. Chair.
Thank you. We'll now open a discussion of whether there was a moral fitness violation. Our options are to affirm, modify, or negate. And in this case, it is dishonesty and misconduct.
Mark Daniel, for the record, I'll move to affirm both.
Who's the second?
Connie will second.
We are voting on a motion to affirm the moral fitness violations. Chair Downing?
Aye.
Vice Chair Colley?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend? And Committee Member Wood. Motion passed.
Now we'll make a motion or move for a motion to take action or take no action. Remember, if you take no action, you need to include why you're not taking any action. Chair Downing, I'll start. I'll make a motion to take action.
I'll second. Okay, for the record.
All right, voting on a motion to take action. Chair Downing?
Aye.
Vice Chair Colley?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood. Motion passed.
Thank you. We'll now discuss the ineligibility period. We'll have a discussion, looking for a discussion and a motion regarding the amount of ineligibility. We are looking at misconduct and dishonesty, which is up to a lifetime ban, 3 years minimum, correct? Correct. From
March 5th, 2021.
that's the one, March 5th, 2021. Looking for a discussion and a motion.
Duncan, I'll make a motion for a lifetime ban because of the impact it had to the community, the cases, and as was pointed out earlier, the clear premeditation to lie. It wasn't spontaneous or anything like that.
I second that motion.
Any more discussion on that?
Voting on a motion for a lifetime ineligibility period. Chair Downing?
Aye.
Vice Chair Colley?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren? Committee Member Townsend?
Aye.
And Committee Member Wood.
Aye.
Motion passed.
We're going to take a 5-minute break for an IT issue. Yeah, sure.
To be sure.
Go for it. Okay, we're gonna go back on the record if everyone's ready. We have one more case.
Alan Lynn, book 3.
Thank you.
Ready, Mark? Thank you.
Melissa Lynn for the record, Chair and Policy Committee members. The department opened a professional standards case for Alan Lynn based on his retirement from the Albany Police Department. His retirement came during an investigation into allegations of dishonesty and neglect of duty related to his submission of a supplemental police report that was requested by a community member. The Albany Police Department sought assistance from the Philomath Police Department to conduct an investigation. The investigator concluded that it was clear that Lynn did not write his supplemental report when he stated that he did. The investigator found 8 separate times where record staff at the police department communicated with Lynn or other management staff about Lynn's supplemental report. The Albany Police Department administratively closed the investigation after Lynn retired without sustaining findings. The department reviewed the information and found that Lynn's intentional conduct was meant to deceive others into believing that he completed a report when he did not, and that he violated the standard for misconduct by failing to submit a supplemental report for several months, which created an inefficient operation of the Albany Police Department and damaged the agency's reputation in the community. The department is seeking a vote to affirm, modify, or negate the department's findings. Mr. Chair.
Thank you. We're looking for discussion or consensus to adopt the record or return it to the case manager for more information. Here we have a consensus. We'll adopt the record. Next, we'll move to discussion of aggravating and mitigating factors. We'll open the discussion. Remember to state your name and identify if it's an aggravating or mitigating factor.
Michelle Duncan for the record. It's actually not aggravating or mitigating, but I forgot at the beginning that I actually do know Alan Lynn and that professionally, and I've worked with him multiple times, although it's been over 10 years. I still think I can remain objective in this process.
Thank you for identifying that.
Thank you.
Thank you.
You want to go? Sue? Livingston for the record. Mitigating factor would be his letter and taking ownership of the conduct and the fact that he was diagnosed. He has a clear diagnosis of a medical issue that the doctor clearly said could have caused some memory issues and confusion and things of that nature. And so that's his letter was compelling to me.
For the record, I can find nothing in the record that indicates how he would have benefited by not completing the report. And again, I think it was a forgetfulness or medical issue based on that. So that's mitigated in my opinion. There is one aggravating thing though. Once he did finally figure out that he failed to turn it in, that it wasn't on his iPad, he lied and did say that it was on his iPad and forgot to report it, or I'm sorry, to transfer it.
It's coming down to the record. There is a part that's a little bit ambiguous. In his mitigation, he does admit that he did that, even though the IT person identified that the amount of time he spent on it was either probably voice to text or done on a different document, which is something that's frequently done because word processing on Word or other platforms is usually a more robust word processing, and so oftentimes officers will write the report on a different document, cut and paste it into the actual report writing system. So before I read his mitigation that says I didn't do it, I was leaning toward he'd probably written it in a different platform, because it just, even as the IT person said, averaging 60 words a minute, which seems very fast to me, would have taken him over twice as long as it would have, as he spent on it, because they time how long. So that was, to me, I was at least enough concerned of, hey, is this did he actually write it somewhere and just hadn't put it into the actual report writing system?
So, Wood, for the record, he actually, in his mitigation letter, he does say that he was intentionally dishonest, that he stated he found the report was.
Right, that's what I said before, this was before, and so.
Before that, I see.
Right, but then we have this issue of his medical issue that was going on, so like I said, I just don't understand, I still don't understand how or why the report didn't get turned in, and then when it did get turned in, how did he turn it in so quickly? How was he able to complete it so quickly if he hadn't written it somewhere already? I don't know if it's aggravating or mitigating.
I was just about to
I
ask.
just talked Jerry, sorry. I just don't know.
Michelle Duncan, for the record, I think what I understood from it is that he stated he then did go back and write it prior to then transferring it, and but he did it like the night before that it was actually turned in. So, I mean, I don't think it was that he just wrote it that day and it was happened that quickly. I still think there was a transfer of the document. It just happened the night before instead of a month before, like he explained.
Other aggravating or mitigating factors? And I would say mitigating is, I mean, so you have a long police career, and then you have, I mean, we're here talking about he did one report, and he did do one report, and there just doesn't seem to be a history of this at all, and there's just no other records of this. It just seems so out of character for him, and then 5 days after his retirement, he's diagnosed with a very serious medical condition that, according to the doctor, could certainly affect your cognitive abilities and your memory. So I do believe that is mitigating.
Wood, for the record, another mitigating piece would be the person that was making the public records request wasn't harmed in any way other than a delay, a continued delay, but there was no harm otherwise.
Anything else?
Connie, I would just second that I think the medical record in this case is very mitigating. And the other piece that I appreciated and would put towards mitigating is that he, when he says he didn't complete the report, he truly believed that. And then when he does then subsequently admit to being dishonest and owns that, and that to me is mitigating that he does own conduct when called on it and when shown proof that that is what happened.
Anyone else? Okay, Melissa, you want to recap?
For mitigating, I have that his medical diagnosis could have caused memory issues, and that the letter that he submitted was compelling. There was no benefit to him not completing and submitting a report. There was uncertainty in the record and the information. He did not have a history of not submitting reports or dishonesty. The person involved in the incident who's requesting a report was not harmed besides a delay in obtaining the report. The medical record was mitigating, and Lynn believed that he did submit it and owned that he was wrong about that. For aggravating, I have that once he did figure out that he didn't submit the report, he was dishonest. And that the night before he went back and wrote and submitted the report, or just submitted the report, and it was not a month beforehand, Mr. Chair.
Thank you. You have a consensus that she's covered our aggravating and mitigating? Thank you. We'll open the discussion now whether there was a moral fitness violation. Following options are available: affirm, modify, or negate, one or all. In this, we've or the staff has identified dishonesty and misconduct. We need a motion.
I'll make a motion that we affirm the 2 moral fitness violations.
Connie will second.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Chair Downing?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Johnson? And Committee Member Wood?
Aye.
Motion passed.
Okay, we're looking for a motion to take action or take no action. If no action is recommended, please include in your discussion why.
Livingston, for the record, I say we take no action, and it's based on his letter and mitigating factors related to his medical condition and that, and him taking ownership over the conduct, and that I don't think that there was any ill will in that in the beginning. I just think that he got nervous when he realized he didn't turn it in when he thought he did, and so there was no real gain. He just got nervous, and I do think that the mitigating letter is super compelling to me.
Barrett, I would second.
Other discussion?
Right, we are voting on a motion to take no action. Chair Downing?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Brandenburg?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Johnson? And Committee Member Wood?
Aye.
Motion passed.
Okay, our next agenda item is applicant review committee nominations. This is a replacement for Alicia Barrett.
Yeah,
Sorry.
Kevin Helper for the record, sadly to say. Tanisha is also leaving the ARC, and we do need to replace her. Those that are eligible from the Police Policy Committee is Sheriff Brandenburg, Townsend, and Public Member Wood, because you need to be in your second term. So again, if you don't know, the ARC meets once a month. It is almost always in the virtual world because it's usually short, sweet, but very, very important to us. Because these are individuals who've been hired by their agency but have reported some criminal background, and we need to determine whether or not they're going to be accepted into the academy and ultimately get certification. So sometimes we don't have the meetings, but we try and do it every month so that if they're pending getting accepted into the academy, we need to be timely. So it's a light lift compared to the 6 books you just had. Again, I want to be respectful that I know you have your day jobs, but yes, looking for a representative from this committee.
What is the makeup of the current committee? Like,
correct me if I'm wrong, you actually have the list, Juan, so.
Yeah, so who's on the committee
Yes.
right now?
The makeup of representations.
yes.
So we have to have, I believe, 2 members from each policy committee. From each policy committee, 2 members, and then 1 public member from the BPSST, and that's about it for now.
And of the current members?
And Kevin Dresser is currently
Yes.
the other police policy committee member.
But I mean, of the, I'm just trying to figure out, is it a police member you need or a public member like Mr. Wood?
He doesn't reinsurance.
The only
Just to keep it
mandatory
balanced.
public is from, actually
From
the
the
board. And so, but it can be anybody here to include a public member.
I will say the reading has very rarely exceeded over 50 pages. It's pretty reasonable. Like, can often be read that morning.
You seem excited.
So if you're looking at me, I'm not campaigning for myself. Either of you don't want it, I will do it, but.
I would nominate public member Rob Wood because I think
I
he
would
does a
second
great
it.
job and he's very. I mean, I really do, And all laughing aside, you do a great job.
Yes.
Here. I always
Yes.
appreciate your thoughtfulness and insight into these cases. You take it very seriously, and I do appreciate that. And if you're able to, I would love to know.
I am able, thank you for that.
She seconded.
She quickly seconded it.
I'm not objecting.
All right.
Really wanted it.
All right, Eric, all yours.
We are voting on a motion to nominate Rob Wood to the applicant review committee. Chair Nally,
Aye.
Vice Chair Connie,
Aye.
Committee Member Barrett,
Aye.
Committee Member Brandenburg.
Aye.
Committee Member Daniel,
Aye.
Committee Member Dresser,
Aye.
Committee Member Duncan,
Aye.
Committee Member Livingston,
Aye.
Committee Member Lofgren,
Aye.
Committee Member Townsend.
Aye.
Should I abstain?
Speech. Motion passed.
Congratulations, good day.
Thank you.
Moving on to agency updates.
Thank you, Chair, full council, for the record. Appreciate the time to be able to be here today. I normally like to start off in a particular way. I want to change the order a little bit in the way I'm starting off. Today was particularly monumentous policy committee for a couple of different reasons. But I want to start off with the staff. The staff worked incredibly hard, and there was a lot of work that went into this, and the professionalism that is displayed here is just, I'm super proud of them and really appreciate all the work that you all did in preparing for this, so thank you very much. And certainly, notwithstanding, I appreciate all of you very much. This is an awesome responsibility that you have here to execute these duties, and appreciate particularly our public members being here, and your opinions super matter in these. So I thank you for your voices here. They're very, very important, and I know this is, Sheriff Duncan walked in with their envelopes still on their books. And I know you all have some awesome responsibilities of your own back in your own work area, so I'm super grateful for that. And I'm super grateful for the leader of this professional standards organization, who we are going to remove her from this job because I need her to do other stuff. And she's trying to do it all right now, and she's doing a great job at all of that. And I wanted to introduce you to the person who will be removing her. She's right over there, and her name is Marie Atwood. And Marie is currently our legal coordinator. She is an attorney. She is a very experienced attorney, and she'll be bringing a whole lot of experience and knowledge to this committee. So we're really happy that she's agreed to take on this role. So welcome, Marie.
Thank you, Bill.
Yes. I talked a little bit about Matt English, the chair of the board and also chair of CPC, and the other day I had to hand him yet another certificate dismissing him from his duties and thanking him for his commitment. I am going to hand another one to Member Barrett, and just want to say how much I appreciate her. I've gotten the opportunity, if you know her, first of all, she's the picture of professionalism, always demonstrates that, has always demonstrated that. She serves, in my opinion, serves her community, serves the state with dignity and honor at all times. If you don't know, she's on the honor guard, and she's awesome at that. So I just so admire all the service that she's given, and thank her for the service she's given to this policy committee.
Thank you, Director. I do want to say a couple of words. I've been planning this speech for like 6 years. And I got emotional with the board just because of some nice things were said, and I do appreciate that. I'm going to try not to do that because I want to get this out. the job that we do in this room is not easy. And I would like the board, yeah, they have like the final stamp of approval, but the work happens here in this room. And the conversations that take place on both sides, for and against, I can feel one way and somebody else can feel another way, but we can have a very appropriate conversation about it and always get to the right decision, in my opinion. I'm grateful that this exists. I didn't even know it existed until director called me and was like, hey, do you want to do this thing? And I'm like, what am I getting myself into? But I now know that if we did not have this, it would open the door for somebody to come in here and do this work for us. And they are not the right people to do this. I love having public members. I pulled Patricia aside earlier. Your opinions matter. Oh, I'm starting to get emotional. We can't do that. Because we can get jaded. Because we can get jaded and we can get sucked into this is our world, this is what we see, this is how I would respond, when that's not always the case and we need that outside opinion. So thank you both for being here. Your opinions are very, very impactful. But also having a space for the non-law enforcement or the non-management folks to feel comfortable to talk in here. We've got a lot of experience in brass and politicians, and it can be an intimidating room, and at first it was very intimidating to me, but I think I found my feet, my voice, and that's because of you guys empowering everybody in the room to have an equal opportunity to say something. So thank you. That's all I have to say. Now,
well, thank you again. I really so appreciate you, and gonna miss having you here, but I'm sure we'll see you around.
Yeah.
And you always have a home here.
Thank you, appreciate it.
Yeah. The updates I'll provide, like every state organization, we're deep in the throes of session right now. Budgets are now being heard. DPSST was one of the first public safety to be heard, and our budget was heard by Public Safety Subcommittee Ways and Means on yesterday. Oof, it's been a week. And within that, and after the May 14th revenue forecast, the state was down $755 million. That had an impact on the outlook of the legislature. DPSST was kept at current service level, which is a very good thing. So all the students that we anticipate training over the next couple of years will be able to accommodate as far as what we see now, what we are able to predict. So that was a very good thing. Not every agency is going to be in those circumstances. Some agencies are going to take pretty good cuts because of that. Unfortunately, as a result of that revenue forecast, we did lose POP 102, which was a staffing package, and we lost POP 103, which was a study to increase the footprint on this academy. So we did lose those. However, our POP 101, which is the learning management system, is still alive. It will be heard in about mid-June with our capital construction. It was lumped into a capital construction / bonding bill that will be heard in the middle of June. So there's a possibility that we could still get the learning management system that was part of the governor's recommended budget. We are going to full Ways and Means tomorrow at 9:30, something like that. 9:30 we'll be in full Ways and Means where our budget will be heard in front of full Ways and Means. Our first go around through Public Safety Subcommittee was 12 minutes. I wouldn't expect that we'll have a long session tomorrow either. That's where I am for agency updates. Pending your questions, I want to open the floor for any questions that anybody might have. You can ask me whatever you like.
I have a question.
Yes, ma'am.
How about the Academy for Children? How is that moving forward?
Yeah. Where's Sam?
He's answering a lot of phone calls.
It's coming along. So Sam Tinney, who is our PIO, our Public Information Officer, he is leading our Youth Academy, which will be happening on June 30th. That's during a down week that we have here, and we're bringing 100 children of high school age. I understand that we've kind of moved towards the high school age children. And we have a whole bunch of partners in this. Many agencies have asked to participate in this, and it's great. It's a big partnership. We're also having fire present and so forth. So this is our first foray into this. And I know you've offered to help, so thank you so much for your assistance there. But we're very excited about our first youth academy here. We don't want DPSST to be this big secret, and we want to do whatever we can to help the profession of public safety grow and attract our youth to it. So that's the aim. This is our pilot. It may get longer if we can be successful at it. And I want to give Captain Kyle Kennedy, some credit here. He came to me with his suggestion to do this, and then he left and is not participating at all. I'm kidding. He's totally participating. I'm sure he's watching this, so I got to take a shot at him. He's been very helpful and very supportive in all of this as OSP as a whole, so I really appreciate it. Thank you.
Thanks.
Any other questions? All right. Thanks again for the opportunity.
Thank you. Any more updates?
No, actually, I'm just going to take a moment to echo the director. You guys all showed up today, and I appreciate it, because I was hoping that your thoughts, your words, there's a lot of people tuning in. As Member Barrett said, if we don't do our own jobs here, then somebody will do it for us. And I was very, very pleased. Proud might be condescending, so you guys showed up. You had the honest discussions on all accounts, but with an elevated one and media present and stuff like that, I appreciate it very much. I too had already said words to Member Barrett, got a little emotional, but yeah. And so I won't this time either, because I do believe she's the face of law enforcement in the future. And her exposure, what she's done, her thoughts that she shared, she shows up every single time prepared, and she's found her voice, and I hope we just continue. Other people who follow in her footsteps will see that outside of rank, that you have a voice on what you want to shape our profession to be. And it's a testament to her and a legacy, hopefully, that we haven't identified for sure who's coming in next on the non-management, but we're working towards that. So again, just my appreciation. And I too, with a great team, am very excited that I get to hand the baton, as much as I don't want to, that Marie will step in, and I only expect her to continue to take us to the next level. And I strongly